I'm sorry, I'm representing myself per se.
And that's fine. You have to follow the rules just like everyone else. Your motion for continuance, ma'am, has already been denied. It has already been denied. You do not get to come before me and argue it again. Nobody does that. You're not an exception to the rule. Is that understood?
Like I said,
Is that understood?
I don't understand how I'm not able to preserve my right to appeal.
You've already appealed this issue that you're trying to bring up. Yes, for today. And you are not going to further delay this hearing, ma'am. You already failed to appear for the exhibit conference. You don't have any exhibits to present to the court today at final trial after the mandate came from the Court of Appeals. There's no record. I have time. I have to be here. So we can sit here all day. It's up to you. When I call it, you don't get to tell me when I call the record, ma'am.
I'm sorry. And yes, I passed through bar exam and I have an LLM, but I spent
Miss Chase, congratulations on all of your accomplishments. I need you to ask him the question.
Welcome to Rebel Chaser. My name is Gail, and I've got a divorce case for you from Judge Bailey in Texas. These two people went through a divorce. Mom didn't like the final outcome, so she appealed. And one aspect has been brought back for a new trial, and that is for just the property division. And Dad has an attorney. Mom is pro se, but she is an attorney. You know what they say about attorneys who represent themselves? There's a saying. I'm not going to repeat it here. But it proves to be correct in this case. This kind of ends in a dumpster fire for Mom. I'll let you guys watch.
There's a lot of evidence that needs to be determined by experts that wasn't presented in trial. And I think that the Court of Appeals has said that there's property division issues that need valuation.
Okay. What I received from the Court of Appeals last, I believe yesterday, I received, it was at 5:40 p.m. They denied your request for continuance.
Yes, ma'am. And the reason it did is because the motions that I have filed have not been verified. The only motion that has been verified through the clerk's office is the denial of the motion for continuance.
Okay, that's not what they said. They said your petition didn't comply with the Texas Rules of Appellate Procedure, and they listed out the rule. And then they also said that you failed to show that the trial court clearly abused its discretion and that relator lacks an adequate appellate remedy. And then they also say that you failed to demonstrate entitlement to mandamus relief. That's what they said.
That's correct. My understanding of that is because we were not able to submit verified orders.
Okay. Well, I'm proceeding because the Court of Appeals, I guess you can say like my boss. They tell me what to do. And they told me that I needed to have another trial on property division. They didn't mandate me to make sure that any type of, what did you just say? Any further discovery. They didn't mandate me to do anything like that. They didn't authorize me to extend any type of deadline. So I'm just doing what I'm told to do. They gave me a mandate to do that. So we're proceeding with trial today. So you don't have any exhibits, just so we're clear.
That's clear. And I just want to respectfully preserve my previously filed objections to the trial setting, the denial of my continuance,
Sure,
and
real quick.
my vote.
Sorry, real quick, can I make sure that nobody's recording? I know there's a camera up earlier, make sure no one's recording in the full right now.
A camera earlier. And Judge Lee?
No, here, I don't know if Ms. Chase's mother she had a phone up like this, if she was recording the proceeding, I just want to make sure it's not going on. Okay.
So I'm sorry, I was interrupted. But I want to respectfully preserve my previously filed objections to the trial setting, the denial of my continuance, and my Rule 245 objection. So those those were never, or the orders were never verified. I was told that my jury demand and my acceptance, or my motion to accept jury demand, the orders would be entered last Wednesday, and they were not. And the acceptance of jury demand and the jury demand orders still have not been entered to this day.
I'm not tasked for anything with the jury demand for today. I'm only required to do what the Court of Appeals tells me to do. If I do anything beyond what the Court of Appeals tells me to do, I get in trouble.
I'm objecting. This is in process, my constitutional right.
Okay, so noted, and it's still denied. So we're going to proceed. Joy, you ready? We're not on record yet. I didn't call the record. And no, and we're not going to do that. We're not, you don't get to say what you're going to call on the record. The Court of Appeals has already, what you're trying to argue before me now. Excuse me, don't interrupt me. The Court of Appeals has already said no to today. Anything you want to do after today is your business. But in terms of today, I would like for you not to interrupt me. That's the first thing. Moving forward, we are going to proceed with this hearing. I'm not going to further delay anything. As I've stated before, I was given very specific rules and directions from the Court of Appeals. That's who tells me what to do. They did not authorize me to go behind them after they have denied your request to go further. So I want to make sure that we're clear before we go on the record. I'm not entertaining it.
I respectfully would like to preserve my right to TRCP 245 and my right for a motion, for a review of motion for continuance and a review of jury demand and a verified order entered for jury demand and my motion to accept.
You said that once and I said no, and we're not on the record yet. I just want to make sure that before we go on the record, you understand the rules. I'm not entertaining it. I will go right back off the record.
I'm sorry, I'm representing myself per se.
And that's fine. You have to follow the rules just like everyone else. Your motion for continuance, ma'am, has already been denied. It has already been denied. You do not get to come before me and argue it again. Nobody does that. You're not an exception to the rule. Is that understood?
Like I said,
Is that understood?
I don't understand how I'm not able to preserve my right to appeal.
You've already appealed this issue that you're trying to bring up. Yes, for today. And you are not going to further delay this hearing, ma'am. You already failed to appear for the exhibit conference. You don't have any exhibits to present to the court today at final trial after the mandate came from the Court of Appeals. There's no record. I have time. I have to be here. So we can sit here all day. It's up to you. When I call it, you don't get to tell me when I call the record, ma'am.
I'm sorry, I was in a hearing 2 years ago where you didn't call it to record and no attorney called it to record, and so it was not on record even though there was a court reporter.
Okay, it calls to record when I say we're on the record, not when you say it. And I didn't call it to record.
She did not ask for a record.
She didn't ask for a record.
I'm asking for a record.
And you're fine to ask for a record, but we don't go on the record until I call the record. That's how it works.
And just from our standpoint, we'd agree. I think you've already issued a ruling on both of those motions.
I did.
I think she's entitled to get a ruling, which you've already given her. She's not entitled to have a hearing and then another hearing and then another hearing and then another hearing.
That is correct. That's not how this goes. When I call the record, we go on the record and we proceed with today. Until the Court of Appeals limits my instruction, I'm going to do exactly what I'm told. All right, Joy, you ready? All right, we're on the record in cause number DL2311677. Counsel, will you please announce for the record?
Yes, Mr. Page, on behalf of Elliott Zimmer petitioner, and we're ready.
All right, and ma'am, would you please announce for the record?
Michelle Chase, ProSe, respond.
Thank you. And prior to going on the record, this case was actually set to begin at 9 a.m. The court gave a courtesy to the parties to allow Ms. Chase to drive in. And there was an exhibit conference that took place at 8:30 this morning. The exhibit conference took place for an hour until 9:30 to give Ms. Chase an opportunity to appear. She failed to appear. Therefore, the respondent does not have any exhibits to tender to the court, and petitioner timely tendered exhibits. So at this time, petitioner's exhibits 1 through 83 will be admitted. Also, prior to going on the record, Ms. Chase attempted to make objections to the court proceeding with the hearing today, or even trying to preserve some sort of record with the court proceeding today. So the record is clear. The court has already denied her motion for continuance. The court has also denied her request to, for whatever reason, stop the hearing or delay the hearing so she has an opportunity to get a forensic accounting of any exhibits. The court is proceeding as pursuant to the mandate that came from the Court of Appeals to have a trial today only addressing the property division, which the court was reversed on and affirmed on everything else. Is that everyone's understanding?
Yes, Judge.
Can I make one clarification?
Is that everyone's understanding?
It's not my understanding.
Okay, so again, as I told you before going on the record, if you're going to entertain anything that the Court of Appeals addressed yesterday in denying your request for mandamus relief after this court denied your motion for continuance, your request is going to be denied at this point.
I respectfully request.
Okay.
Notification. I did not receive notification. I was here at 9 a.m. Did not receive notification that the court would be delayed.
Okay, ma'am, I haven't sworn you in yet, but there is an entire email thread where you thank the court, actually. You thank the court for accommodating the parties, and counsel can verify that that is an email. So we are not going to do that today, ma'am.
Not notified that the court would not.
Oh, it took place yesterday. You responded yesterday in the email.
And Judge Cards, if it's P82 and P83, that is the email thread you're referring to, so that's in the record.
It's a part of the record, ma'am. You responded. So at this time, counsel, you all have an hour per side. Ms. Chase, you also have an hour. Let me make sure that my clock is working today. It's been giving me problems.
Clarification. The email date, the court was going to begin at 10 a.m. to give me a chance to get here driving from Arlington to have a pretrial conference. I don't believe that it did.
I believe Judge Lee did say that she can have the conference this morning at 8:30 and do the trial, talk to the bit for the trial starts.
I'm not, you all don't have to speak to each other. I'm not entertaining any further testimony about that because you can open your email and look at it yourself, ma'am. All right, so my clock is working. Attorney Page, Ms. Chase, you all have an hour per side that would include any opening and closing statements, as well as any examination. Attorney Page, would you like to make an opening statement at this time?
Yeah.
You may proceed.
Thank you, Judge. So, as you know, obviously you heard this case 2.5 years ago, for all the issues. Now we're back on property division. I want to be, obviously the Court of Appeals has remanded the entirety of the property division, but the sole issue that Ms. Chase had that the Court of Appeals found issue with was the performance units that Mr. Zimmer had through a prior employment. So, as we sit here today, with the exception of 2 assets, the parties have already divided up their estate. Now, obviously, with the remand of all their estates property, but it's down to the actual issue of, if we've got a 401k that is divided 55-45, we've already got Quadros dividing that. The money has been spent on both sides. No, Ms. Chase is represented. She has no money, so she spent all the money from the divorce. Mr. Zimmer's paid off all his debt from the divorce. They had a Dallas house they sold off and split the proceeds of, and most of that money has likely been spent by now. So while we are here on a remand for the entire property division, our position is that there's also practical issues that we've already divided up most of the estate. So prior to coming to court last time, or the beginning of court, Ms. Chase's counsel and myself, or I should really say Ms. Chase and Mr. Zimmer, reached an agreement for an overall 55-45 division of the estate. which is an agreement you approved, and that I didn't see as part of the Court of Appeals, any part of the agreement. So as we sit here today, my understanding is we still have an agreement for a 55-45 division of the estate. We've submitted a property division, which is attached to our exhibit 1. And I've got a free-floating version later on as well. What we are asking for you to do today, by and large, is going to be exactly what you did last time. There's only going to be 2 changes what are the 3 changes we're asking you to do today. First off is what the Court of Appeals wants us to do today, which is take the performance units which the Zimmer has and divide those in half. So 55% going to Ms. Chase, 45% going to Mr. Zimmer. The other thing is you ordered, at the time of the last trial, the parties had 2 pieces of real property. They had the Dallas house, which has long been sold. Mr. Zimmer was in charge of selling that property. Then you've got this Cloudcroft, New Mexico residence, which is where Ms. Chase still currently lives to this day. You had ordered that to be sold at the time of the last trial, and unfortunately, proceeding today, that still has not been sold. So Mr. Zimmer has not only filed an enforcement action in this court before, which you clarified that this house needed to be listed at fair market value. He then had to file a case in New Mexico to ask a receiver to be appointed to sell this property because Ms. Chase just refuses to put this property for sale. She's living there, and she's not paying anything other than utilities and probably minimal property taxes. And as long as she sits there, Mr. Zimmer's 45% of those proceeds is just held up, and they're both spending more on attorney's fees just trying to sort that. So we're not asking to divide the proceeds from that property differently, but what we are asking you to do today, Judge, is to order that Mr. Zimmer has complete control over the sale of that property, that Ms. Chase have to provide whatever consent is necessary for him to sell that, and that she vacate the property within the next 30 days. I think if you don't order those provisions on there, this house is never going to be sold, and they're going to spend more than the house is worth in attorney's fees. The last thing that we're asking for that you'll see is we're just asking for attorney's fees. We sent Ms. Chase, frankly, Mr. Zimmer has sent her a number of reasonable settlement offers throughout the multiple cases that we've had with Ms. Chase. We sent her a reasonable settlement offer just about a month ago saying that let's just keep the property division the same, and then we'll give her 55% of these performance units. She didn't counter. She refused to accept it. She declined it. And so now he's had to spend attorney's fees for us to be back here today, including us just trying to fight this in the Court of Appeals yesterday and responding to that motion. So we're asking for attorney's fees there as well. So other than those changes, though, Judge, we're asking you to keep the ruling in place. That'll be in comporting with the 55-45 division. And that way, I think your property division has fixed the issue the Court of Appeals have, and it also doesn't create practical issues for the 2 of them dividing the remaining proceedings. So thank you, Judge.
Thank you. Ms. Chase, this is your opportunity for your opening statement.
Thank you, Judge. So what I'm asking for is information regarding the Morgan Tool unit, whether or not he's taken severance or a cash payout, and anything that could dilute the shares that I am ordered 55% of. In addition, the Dallas property was sold in less than 2 months of it being listed. We have both agreed that the value of the property was between 3.2 million and 3.7 million. He sold it in an all-cash transaction for 2.7, 16% less than tax roll value. I would like emails between the realtor and anybody else to find out if there were deals that diluted the value from 3.5 average to 2.7 all cash. And I would also like wire and transfer information on where that money actually went. That's a lot lower than we had both agreed the value of the Dallas property was. In regards to the Cloudcroft property, I was not on the deed of the Cloudcroft property. You had ordered that I listed for sale August of 2024. I was not on the deed. It was a legal possibility. As soon as I was on the deed, I listed it immediately. It has been listed since. It is still listed by a broker dealer who has been a broker dealer realtor in Cloudcroft for probably 50 years at this point. Cloudcroft is a seasonal resort town. It takes a lot longer for properties to sell. I have kept up the property. I have been paying property taxes. I have done upgrades to the property. I've allowed showings. I keep my property immaculate. So if there is a showing, when I'm out of town, anybody is able to go into the property that has been shown. People love the property. There are certain things that make the property difficult for some people. It has four sets of stairs. It is not my fault that the property is not sold. I have done my due diligence on trying to sell the property. As far as our estate is concerned, he took our entire savings account. He took all of our severance for 5 months and put it into a separate account or wire transferred it out of our account. There was almost $1 million missing out of our estate that I did not have time for a forensic audit because the last trial was expedited as well. That's why I'm asking for continued time to find out where this money had gone. In addition to that, I was only allowed in discovery to receive summary statements of our retirement accounts. I wasn't allowed full statements. It was ordered that summary statements are full statements. Well, unfortunately, that's not the case. Summary statements of retirement accounts only show you what money has been lost and what your account balance is. It doesn't show where the money that's been taken out or transferred went. I need that information. That is part of our community estate. I have a lot of missing funds.
I guess an objection,
sorry.
to the extent this is now getting into a request for continuance that.
Sustain. In an opening statement, ma'am, you're telling me what the evidence is going to show and what your request is for today.
Okay, so they presented P82 in trial. And it's a summary of our monthly expenses. That was allowed in. We objected, it was overruled. There were no financial statements supporting this summary. And I know for a fact that line by line, this entire summary that was substituted under oath was a lie. For example, ESD over $6,000 a month, he said we were paying monthly. We paid ESD the year before out of community property. ESD tuition is due February of the year before your child attends. Line by line, I can go through and tell you that this was brought on the court and it was testified to under oath.
Okay, does that conclude your opening statement?
Other than I would like to preserve, my previous.
We're off the record. I already told you we're not doing that. Does that conclude your opening statement? Thank you. We're back on the record. Is the realtor that you were referring to, is that the Loper person?
It is Skip Tideline.
Okay, so that's someone new?
Yes, so, when I originally listed the property with Debbie Lippert. Spell her name, D-E-B? D-E-B-B-I-E-L-O-P-E-R. Thank you. I had comps. I had, everything prepared. She listed the property. And then, he had my realtor.
That wasn't my question. I just need to know, was the realtor still Loper?
No, because she was interfered with. I would like to also make one more statement. He has,
Is this in your opening statement? Because if it's not an opening statement, you'll have an opportunity to tell me what you want me to know after his case in chief. I mean, if it's an opening, if not, he's going to object to it.
Okay. Well, he has had me through the deed of trust, ensure the Babcock residence for $500,000. And I listed it for $545,000. So it's fully insured at the request of petitioner for $500,000, full property. And I have that documentation here, and I've done everything requested to ensure that I'm complying with the deed of trust and everything that's been asked of me. And I've completed it.
Thank you. Attorney Page, you may call your first witness. Okay.
And also, I think for, Mr. Chase, we'd ask that the rule be invoked at this time.
Okay, and thank you for saying that. Would the two of you stand up and raise your right hands? Or mom too?
I'm on fine.
Yes, everyone. Do you all swear or affirm that the testimony you give would be the truth and the whole truth?
Yes.
Yes.
Thank you. So the rule has been invoked. So, sir, you may go ahead and have a seat because you're the first witness. Just pull the microphone to your mouth. Ma'am, the rule has been invoked, meaning that anyone who may testify as a witness has to sit in the hallway and wait until the bailiff comes and get you for any testimony. You're not allowed to speak to anyone on this case, and you just have to wait in the hallway. I swore her in as a witness and he may call her, so he invoked the rule.
State your name for the record.
I am with a Y, Charles Rice.
And can I give you, will we give you a, I'll be glad if you have me, so can I approach witness, Judge?
Yes.
And you all exhibits. And my issue is referring to tab number 68.
Yeah, it's on there.
And is this your CV?
Yes,
It summarizes all of your education, credentials, experience, all of that.
yes,
Okay, and you've been designated a number of times in cases to testify as a financial expert in divorces in Texas.
many times.
Okay. Can I use you to turn to tab 69? And
Yes.
is this the engagement agreement that Mr. Zimmer signed engaging your services in this case?
Yes,
All right. And as part of your employment in this case, what have we asked you to review and testify about today?
so I was asked to review and testify about the performance units that Mr. Zimmer had obtained in the course of his former employment with Oregon Tool.
Okay.
And basically the characterization of those and then commentary on the value of those.
Okay. And can you briefly explain how the performance shares work for?
Sure. So the performance units are, so Oregon Tool is owned by a private equity firm. And key employees like Mr. Zimmer gets performance units so they can share in the upside of the company, so to speak, only though upon the occurrence of certain events. So to some extent, they kind of are a cousin, so to speak, of say stock options, where a stock option is where a person, assuming the price of the underlying stock gets to a certain point, the stock option has value, the fair market value of the stock less the strike price. There's many, many variations of stock options and similar items, and this is one of them. But a performance unit really is just something that could have value someday, but it really has no ascertainable fair market value until certain events occur. And in this case, the events would be a sale of the company or an IPO of the company or a cash distribution paid to equity holders. And those events are completely unknown as to the timing or the certainty or the probability. So these performance units, in this case, and I've encountered them many times before in other cases, they just don't have any ascertainable value at the point in time, because there's no information available that tells us when any of those events will occur.
And these performance units, do they expire at some point?
Yes, these performance units will expire by their terms on December 31st of 2028.
And so as you testified, I just want to make sure that I've got it straight as well. So they have no value right now. They wouldn't have a value, if any, until we have some qualifying event like a sale or an IPO.
Now, those are outlined in section 7 of the governing document, the 3 events.
Okay.
That will tell us, so it's something we can't, with all evaluation tools we have, we just can't assign any value to it at this time.
And this is not a public company. We can't Google what the stock value is, right?
Right, but the stock value has no relevance anyway, because it's due, remember, IPO, so it's a private company, so it has to be an IPO or the sale of the company or a cash distribution of equity. Those are the three
Two
events.
equity holders, is that what you're saying?
Yes, equity, yes.
And as we sit here today, none of that has happened, so Mr. Zimmer's not receiving any money for these shares right now, is that?
It's my understanding, none of those items, none of those events have happened.
Okay.
Correct.
Is it your understanding Mr. Zimmer is no longer employed with Oregon Tool?
That's my understanding.
Okay, so the time of the last trial, Mr. Zimmer was employed with Oregon Tool, right?
That's my recollection.
And so if you turn to, can I just turn to tab 71 in front of you?
Yes,
And this is the OT Holding Corp, which is OT Holding Corporation is Oregon Tool, right?
right.
And the 2021 participation plan, is this the plan that provides for these performance units?
Yes, it grants them, yes.
Okay, and then if we turn to, I'll have you look at 73 first. Was this one of the grant agreements that Mr. Zimmer got?
Yes, there were two.
Okay, so this is, and you see the date of grant says November 2022.
November 7th, 2022.
And so if I call this one the 2022 grant agreement, will you understand this is the document referring to?
Yes,
Okay, and then if you turn to 74, same thing, we've got a grant agreement from July 29th, 2023.
yes,
And if I call this the 2023 grant agreement, do you understand what I'm talking about?
yes.
So under both of these grant agreements, was there a vesting schedule that you would receive and then have shares vested?
Yes,
Can you turn to exhibit 75 now?
yes,
So since Mr. Zimmer is no longer employed, is your understanding that the vesting schedule is largely irrelevant at this point?
yes, there's a set amount that he owns.
Okay, and in this letter, does Oregon Tool explain exactly how many shares Mr. Zimmer has as we sit here today?
Yes,
Okay, and they actually refer to the 2022 grant agreement and the 2023 grant agreement, right?
right.
Okay, so we sit here today, we know how many units he's got, but we've got no idea how much they're worth.
There's no way for anyone to know what the work.
Okay,
We don't know, and no one else knows, because there's no timetable, there's no projection, there's no forecast of when these events would occur. And we wouldn't know the magnitude of those events.
or if they ever occur with it.
But yeah, we don't know, we have no information, so so as an aside, these items in IRS parlance have no ascertainable fair market value. And that way, when they're actually granted to people like Mr. Zimmer, there's no taxation at that point. So there's no value to them, so there can't be any taxation at that point.
And so, do you recall last time we were here, you talked about how really the only way to tackle these is to divide them in kind, since we don't have a value for them?
Yes, that's how most stock options are divided anyway. I mean, even stock options are divided that way. They're typically not valued. But these are absolutely, the only way to do it is divide them and in kind, and then each person would get any benefits on an equal basis.
And so, as you sit here today, you agree that what we've got to do today is just divide these in kind?
That's yes, absolutely.
Okay, I'll pass it to Jay.
Thank you. Ms. Chase?
Hello.
So I'm unfamiliar with the way performance units technically work. I have read somewhere that at one point there was a value of like $1 per unit or something, but that could have just been an example that I read.
To decide, our judge.
Sustained question.
You tell me if performance units can be negotiated out of or devalued by severance or cash payout before or if the triggering event occurs.
It's highly unlikely. I guess as we say, anything is possible in the world, but these performance units and others like them are just governed by a strict agreement that typically cannot be deviated from. And whether somebody has the power to go in and make a unilateral change is almost unheard of. So I've never seen it in practice in 40 years as a CEO.
Would you agree that that would be something that I should be able to check into and be concerned about?
Well, I mean, as a qualitative matter, I think you would be entitled to discovery and information that's available in the normal course of business. But in terms of, I mean, these agreements are, the terms of these agreements are in the four corners of the documents. And there wouldn't be any way, in my opinion, or any reason for someone to need to go past that. It's just an agreement. Here, you get performance units. they may be worth something someday, they have a specific vesting schedule, they have an expiration date, and if it pans out, great. And that's pretty much it.
But would you agree that there could potentially be, at the time of separation of the company, an agreement that negates some of what has already been agreed on or alters some of what has already been agreed on in a new agreement with the separation of the company?
Judge, I'm gonna object to calls for hypothetical.
Sustain.
Would you agree that there could be a severance agreement that could, I mean, would you agree that there are typically severance agreements?
Judge, I'm gonna object to calls for hypothetical. And calls for speculation.
Sustain as the speculation.
Are severance agreements typical?
Judge, I object to calls for speculation and also goes outside the scope of Mr. Rice's testimony.
Sustain as to outside the scope.
I have a question.
Anything further for Mr. Rice?
Real quick, Judge, Mr. Rice, have you seen any documents that would indicate that these shares have been devalued or negotiated around or anything like that?
No.
Okay, pass notes.
Okay. Is there anything further for Mr. Rice?
Yes. Have you been provided any other documentation besides what has been provided to you by opposing counsel?
No.
Thank you.
You're welcome.
Okay. Anything further?
No questions, Judge.
Is Mr. Rice free to be excused?
Yes,
Okay. Thank you for your time, Mr. Rice.
You're very welcome.
You're welcome. Counsel, you may call your next witness.
we call Mr. Zimmer.
Okay. Same thing, Mr. Zimmer, just pull the microphone to your mouth.
You state your name for the record.
Owen Zimmer?
And you were previously married to Ms. Chase, right?
Yes.
Okay. We previously had a trial on this case, is that correct?
Yes.
And was Ms. Chase happy with the court's ruling?
No.
And what did she end up doing? Because she was unhappy.
She appealed.
Okay, and so why are we, as it relates to the appeal, why are we back here today?
To determine what they will be the performance units for individual.
And can I have you turn to exhibit 1 today?
Yeah.
And in addition to performance units, there were also, we're here on the other property division issues too, right?
Yes.
Okay, but the performance units was the issue the Court of Appeals had.
Correct.
Okay. So the Court of Appeals didn't have an issue with how your 401k was divided?
No.
Didn't have an issue with the proceeds from the sale of either house being divided?
No.
Okay, so none of the other stuff was an issue.
Yes.
Mr. Page, slow down real quick.
I apologize, I'll,
I'm not, didn't have an issue with the proceeds of the sale.
from the sale of either residence. And I think I asked him if the Court of Appeals didn't have an issue with any other property division issues.
And I'd like to object to that.
Okay. What is your legal objection?
My legal objection is that the Court of Appeals remanded the entire property division.
And Judge, that's not what my question was. They did remand the property division, but they remanded it because of.
You're saying specifically in the opinion?
Yes, correct. We are here today for the whole property division, but it's not as if they said the 401k was divided wrong or anything else. They just said the performance units had to be divided in kind, so we've got to divide them. So
I'll sustain in terms of how the question was asked, rephrase.
when the Court of Appeals remanded the entire property division, in their opinion, the only thing they mentioned as error was the performance units. Is that correct?
Correct.
Okay. So I went to looking at exhibit 1.
I'm sorry, I'd like to object to that.
Okay. What's your legal objection?
My legal objection is that if they only found error with the performance units, they would not have redivided the entirety of the property.
Okay. So what is your legal objection?
My legal objection is that that's wrong. That's more hearsay. That's not what the Court of Appeals ruled.
Okay. Overrule.
Thank you. So Billy, going through this exhibit 1, so we've got a spreadsheet attached here that this is what you're asking the court to do today, right?
Yes.
And then you're asking the court to order Ms. Chase to pay your attorney's fees in association with what you've had to pay for this remand, right?
Yes.
And on a Cloudcroft residence, are you asking, so at the time of the last trial, well, I'll go into this detail more, but you're asking for some changes on the Cloudcroft residence, correct?
Correct.
Okay. I want you to turn to exhibit 13 right now. And is this your inventory appraisement from the day before our last trial? Yes. Okay, so if we're looking at the value as the time you value the asset that at the time you guys got divorced, this is our most up-to-date document, shows what those values was. Yes. Okay. And then I won't go through each one of these, but are you familiar with the exhibits P14 through P40? Yes. And those are each like statements or other supporting documents for each of the assets that are in the state. Correct. Okay. And if we looked at P47 through P56, are those supporting documents for each of the debts in the state? Yes. As far as your independent appraisement, if we were to go line by line on this, and you were to talk about each asset in your community estate as of the date you got divorced, debt in the community estate as of the date you got divorced, would this document accurately summarize your testimony on that issue? Absolutely. Okay.
I'm sorry, which document are you referring to?
13. Can I get you to turn to page or to tab 63? Okay, and is this this court's rendition of ruling from your divorce? Yes. And it's dated March 20th of 2024, right? Correct. That was the date that the court divorced you. Correct. Okay. Can I get you to turn? I just want to go through some of these with properties. So can I get you to turn to page 2? Yes. So if you look a little more than halfway down, you see there's the following confirmed to husband/father. So all the bank accounts sold in your name, those were awarded to you, right? Yes. Okay. And in the last 2.5 years, have you had both living expenses and attorney's fees to pay? Yes. Did some of that money come out of the bank accounts? Yes. Okay, and so the money that was actually awarded to you on March 20th, 2024, is that money still in these accounts? No. What about there's a promissory note to Harry Zimmer. So who's Harry Zimmer? It's my father. Okay, and you owed him about $131,000 at the time of trial? Yes. Have you since paid off that promissory? Yes. Okay, so is there any way for the court to redivide that and have this Chase pay a portion of it if you already paid the whole debt? No, not practically. Okay. What about let's the 50% of the 2023 tax liability. Have you already paid that tax liability? Yes. Okay. And so there's no way to redivide that and pay it some other way because the money's already gone. Correct. Okay. Can I get you to turn to the next page now? You see there's the section that says real property. Yes. And you see the first one is the marital home on Walnut Hill Lane in Dallas. Right. Okay. Did the court order that to be sold? Yes. And who was in charge of the sale? I was. Okay. And did you sell that property? Yes. Did you, once it was sold, how were the proceeds divided between the checks? 55% to her, 45% to me. And you guys have since divided up those proceeds? Yes. About when, if you recall, about when did that set? It was in the fall of 2024. So almost 2 years ago. Correct. Do those proceeds, as far as you're aware of, just on your rate, the 45% proceeds, do all of those exist as we see today? No. So you've had to spend that money or some of that money that I basically paid back my debts. Okay. And you've heard Ms. Chase represent a number of times in this case that she has the money, correct? Correct. So that indicates that she's paid off she's spent all of the 55% she got from this house. One way or another. Do you recall the closing statement or the settlement statement you got when you sold this house? Yes. And how it divided up the proceeds between you two, right? Yes. Was there a line item for money that was owed to Ms. Chase's prior attorneys that represent her at the last trial? Yes. Okay. Is your understanding that, or your presumption that she's paid that debt off? I'm not sure. I think there was. They got split 45 to me, 55 to her, and my understanding is that there was a lien and she had to work that out with the lawyers, and I'm assuming that I'll consult it out. Okay. So just to be very clear and blunt, as far as the proceeds from the Walnut Hill Lane residence, do all of those proceeds even exist today for the court to redivide in some manner different from the way it divided in 2 years ago? No. Just real briefly on the Cloudcroft residence, because I'll ask you about this later. It has, would that be supposed to be sold as well? Yes. Has it been sold? No. How much of the proceeds were you entitled to? 45%. So you have not received your 45% as it's no. Okay. skimming through the cash and accounts for financial institution. It means this. You and her divided up the accounts in a manner that Judge Bailey ordered in this.
Yes.
Is all of that money on your end at least still in those accounts? No. So is there any way to redivide those to different hands then?
No.
I want to turn to the next page. Same thing with the brokerage accounts. So you guys divided up those accounts that way?
Yes.
Do all of those funds exist as we see?
Not that.
Okay, the Oregon tool bonus, did you guys divide up that?
Yes.
And do all of those funds exist today?
No.
What about the retirement benefits for the 401k? Is there a quadro the court signed to divide up that 401k?
Yes.
And so you've got your part, she's got her part.
All the retirement accounts now, it's split 55 to her, 45 to me with that quadro.
And they were split, you weren't taxed for the distribution because it was a transfer instead of divorce.
Correct.
Okay. Would you have concerns for the practical nature of trying to bring those accounts back without taxable consequences? Yes. Be divided in that way?
Yes.
With the stock options, so we'll talk the performance units in a little bit. You are asking your court to divide those up differently today, right?
Correct.
Okay, and that's in line with what the Court of Appeals said.
Yes.
Okay. Club membership and travel were benefits. And you guys are.
And travel what? Slow down, Mr. Page.
Sorry about that.
That's okay. Club membership
Club
and travel what?
memberships and travel award benefits. Have you and Ms. Chase divided up these accounts in the manner that they're ordered divided here?
Yes.
Do all of your airline miles and travel award benefits that are listed here, do they still exist as of today? And just for the record, if you just wait for me to finish the question before you answer the question. So the motor vehicles down at the bottom of the page, there's a 2018 GMC Yukon. Does that car still exist today?
No.
Have you sold that off?
Yes.
Is there any way to now award that to Ms. Chase?
No.
If you can turn to this next page. There's credit cards and charge accounts, and there's 5 different credit cards listed. You see that?
Yes.
And they're all already paid by you, correct?
Yes.
Did you pay all of those?
Yes.
So those debts don't exist.
Correct.
Okay. So just to, and I'm sure that, you know, we're going overboard on this, but you're asking the court from a practical standpoint, not to redivide other assets because we've got division that's already, that's right.
Right.
There's,
Yes.
what are some concerns? So if the court were to redivide the assets, like let's say it takes an account who's converted to you and splits it up 55-40. Takes an account over to this Chase and splits it up a different way today. What would be some concerns you would have from a practical standpoint?
Yeah, I got 3 concerns. You know, practically speaking, going back 2.5 years, trying to revalue everything with different, parties and all those kinds of things, practically speaking, it's impossible. Secondly, it would be expensive. So people that try to do it, try to bring in accountants, lawyers, third parties to try to put all that back together and people that can understand all that stuff. So it'd be extremely expensive. And then third, we're 2.5 years in now and we still haven't divided the estate. And so then trying to redivide after getting all the accountants and the lawyers, I can only imagine how many times we'd be back in court trying to figure out what to do with each and all of these different items.
Yeah, so talking about that last point, just the money that you have to spend to get these things right. What's the relationship between Chase and that?
We don't talk.
Okay, are you able to productively discuss anything?
No.
We talked about the firearm residence. Obviously, that's not sold 2.5 years. Like, what have you done? I'll start just in Texas. What have you had to do in Texas to try to get that sold?
Yeah, I had to come back to this court with a motion to enforce.
And did you have to pay all law firm attorney's fees to have that happen?
Yes.
And the court ordered some attorney's fees against Ms. Chase then,
Correct.
did she ever end up paying those?
No.
In fact, she appealed that as well, right?
Correct.
Did you have to pay us attorney's fees to defend that?
Yes.
What did you have to do then in Mexico to try to get this New Mexico listed?
The divorce decree said that we were allowed to appoint a receiver. So then
in New Mexico, I had to go hire another attorney to then go down the process of wanting a receiver and ran into the same issue. So at this point, I spent tens of thousands of dollars trying to just get a receiver appointed, to which that hasn't really worked itself out, for good reasons.
So if, let's say the court takes one of the assets that was awarded to you or to Ms. Chase, redivides that. Do you think that Ms. Chase would cooperate with you and redivide that easily?
No,
Do you anticipate we have to get at least some funds involved to get that divided?
yes,
And that's the extension you don't want to extend.
correct.
You've been, this is not the only lawsuit you've had with Ms. Chase, right?
Correct.
You testified about the New Mexico lawsuit. You testified just now about the enforcement lawsuit in this court. She filed 2 appeals out of this case.
Yes,
That she filed eliminating the citizen of this case.
yes,
And for each one of those, she had to have us represent.
yes,
And then there's also a modification case which is pending right now.
correct.
And she had just asked for a jury trial and it was early this year.
Yes,
Has she seen your daughter, who's still a minor child? Has she seen her in the last year?
no,
Does she still wants a jury trial on that issue?
yes,
So are you ready to be done with all the litigation in this case?
I just like to move on.
I want to go here to you turn to 64. And this is the, well, then let me turn to 66, actually. Are these the findings of fact and conclusions of law that this court signed after our last trial?
Yes,
Can I get you to turn, so there's an exhibit A attached to the back. Can I get you to turn to page 2 of that?
yes,
And do you see how the court has every single asset from the estate listed with a value?
yes,
And so those are the values, as you understand, that's the value for each of these assets that the court found out of the evidence instruments.
yes,
Okay. And then if we go to the next page, or we starting on the next page, we see the same thing with the debts, where Judge Bailey looked at the evidence and found a value for each of the debts.
correct.
I want you to turn now to exhibit 67. So this is your proposed property division,
Yes,
and this is identical to what's attached to your exhibit 1.
yes.
Okay, I want to go through this real quick.
With some, it's identical with some exceptions.
Yeah, well, it's identical to the one on exhibit 1, though, right?
Yes,
Okay.
same spreadsheet.
So, and then with the exceptions, most of these values are the same values that Judge Bailey found for the original trial, right?
Yes,
Most of them would also then be supported by your exhibit. You've already admitted into evidence that support the values for assets.
yes,
Okay, I want to talk about the exceptions, like I mentioned. So you see line 1 under real property, where it lists the Walnut Hill residence,
yes,
is the value listed is $895,000 and it's a change. Is that different than what the court found from this last trial?
yes.
Why is this different?
It is the net proceeds after the sale and after we paid off the mortgage. So what you'll see in the spreadsheet is there's no longer a mortgage in the debt section. But after the sale, because the mortgage was paid, so it's the actual net proceeds from the sale of the loan.
Okay, because at the time of trial last time, this house had not sold, right?
Correct,
And now that we're 2.5 years later, we know what the value is because you have sold.
correct.
So this reflects the actual amount going.
Yes,
Okay, I want to go down to line 13 under stock options. You've got the OT Holding Corporation performance units.
yes,
Are those the performance units that would be issued or be appealed?
yes,
Okay, and last time the court awarded 100% of them, correct?
correct.
How are you asking that they be divided today?
55% to Ms. Chase, 45% to myself.
And that is in line with the agreement everyone reached before trial last time for a 45-55 issuance.
Yes,
It also says total of 4,506,840 units.
yes,
At the time of the last trial, were you employed by Oregon?
yes.
Is there a whole vesting schedule for how many units you had would get to invest over time.
Yes,
Okay. And as you sit here today, are you still employed with Oregon Tool?
no,
When you left Oregon Tool, did they confirm the number of shares that you told them?
yes, based on that vesting schedule, based on the time that I left Oregon Tool, it was calculated, and that's that 4,506,840 is the amount of units that vested that I've been left Oregon Tool with.
Okay, so if we look back to even information available at the time of the last trial, we could calculate the vesting schedule, right?
Yes, and it needs is
And when did you leave your employment with Oregon Tool?
in basically May of 2025.
Okay, and so in May of 2025, this is the number of units that already vested.
Correct.
Okay, and so they said they let you walk away with the vested units and you didn't get any units that were not vested.
Correct.
Okay. Are there, well, I know I'll move forward here. Going down to, let me have you turn to the next page. You see at the very bottom of the liability section, item number 10 is the 2023 tax liability.
Yes.
You have $41,805 listed. Is that how much was listed at the time of trial?
Yes.
What was listed at the time of trial then?
I don't think so because it was right before tax season.
So, had you paid taxes in March of 2024 for the 2023 season?
No.
So did we have an estimate for what you thought taxes were?
Right.
Okay. Since then, you now paid those taxes.
Yes.
So now, where do we get this $41,805 thing?
That's the actual amount that's paid.
Okay, so other than the amount of the taxes, the net value, the net proceeds from the Walnut Hill residence and the division of the actual units from the performance units, the rest of this is all the same based on what the court found last time.
Yes.
Okay, and real quick too, going to the Cloudcroft residence, because I want to talk to you a little bit about that next. You've got a value listed at about $397,000.
Yes.
Have you, even throughout the lawsuit in this case, we worked with at least one realtor who works out in Cloud.
Right.
And based on comps and what she's testified to, do you believe that $397,000 is an accurate figure for what that property was worth at the time of the divorce?
Yes.
Okay, so you still stand by this 397 figure?
Yes.
Okay. So let's talk more about cloud conferences. I think we probably hit most of the points already, but do you recall, so the court ordered that house to be sold, right?
Right.
And the court put a deadline for that house to be sold.
Yes.
Was there an issue where Ms. Chase had sent you like the listing agreement the day before, the evening before it was supposed to be listed?
Something like that.
Was it just a listing agreement or were there like asterisks that she had told the realtor to put in?
Or was there asterisks?
Asterisks, yes. That she told the realtor.
Yeah, the if I remember correctly, the realtor wanted me to sign something basically waiving my ownership stake or something. That's just view, but
And did it get listed because that did get listed by the deadline?
right.
Correct, it was not listed by the deadline.
It was not. It's
When it finally was listed, was there an issue with the way that it was listed?
yes.
What was the issue with how it was chased listed?
She listed it with a price that was way above the 397.
Do you recall, was it about just under 600,000?
Yes, over 5,000.
Okay, which was not at all in line with what the evidence showed.
Right.
As far as you're aware, have there been any prospective buyers for the property in the last 2.5 years?
As far as I'm aware,
Did it get taken down from being listed at some point?
for a while.
Okay.
Yes.
And so today, one thing you're asking, so in the last ruling, Ms. Chase was given control of the South New Mexico residence, and you were given control of the Delta Dallas residence.
Yeah, and she was told by this court to list it at a price where you get willing buyers and willing sellers to come together. So basically told to take the price down to a place where the market would.
Objection. That's not what we said.
Okay, what was the legal objection?
Objection, that's not, it's false information.
Judge, I think she can cross-examine, that's the case.
Yes, overrule.
So with you being in charge of the Dallas house, that's the only house that has sold. Right?
Yes.
You heard Ms. Chase even just today say that something went, she made some sort of allegation that there was some underhanded stuff with the sale, you sold it for way less than it was worth.
Right.
Okay. Do you believe you sold it for less than it was worth?
No.
Okay. Did you work with a realtor to get it sold?
Yes.
And did the realtor did he think that was a good price to sell it?
Yes.
So you're asking the court to give you now that we're coming back and doing this a second time, one of the changes is you want to have control over the sale of the next door list, right?
Yes.
Do you think that's the only way we're gonna get this thing sold?
Yes.
As part of that, are you asking that Ms. Chase be ordered to vacate that residence?
Yes.
So is she living there right now?
Yes.
There's no mortgage on it, is there?
No.
So other than utilities, and property taxes, she doesn't have the expenses for the property?
Correct.
Okay. Do you think that she's motivated to sell the property?
No.
Do you think she has motivation not to sell the property?
Yes.
And that's clearly evident by the fact that we're 2.5 years later, we haven't even got an offer on the property.
Correct.
Okay. But you're still asking the court that once you sell it, split it up 55-45 like the old estate.
Cool. Correct.
Okay. Before I go to the performance units, I want to turn your attention just real quick back to exhibit 67 in front of you. Can you turn to the second page?
Yes.
So you see down at the bottom, you add all these values in, it's got about 43% to you and 57% to Ms. Chase, right?
Right.
Okay. So you guys agreed to a 55-45 split.
Right.
And technically this is actually a little more favorable to Ms. Chase.
Yes.
Okay. Are you asking the court, are you fine with it being a 57-43 if we can just get it done today?
Yes.
Okay. Like you said earlier, it's ready to have this be done.
Yes.
Okay, so you're making no objection to 57-43.
Correct.
Okay. Let's talk about performance units. Well, I guess I've asked you some questions about those. On the Clowncoff residence, you understand Ms. Chase was trying to argue at the last file that that was a gift to her.
Yes.
Did you gift the Clowncoff residence to Ms. Chase?
No.
There was, so the deed went from being in your name to both of y'all's name, correct?
Correct.
Can you explain for the court why that's the case?
Yeah, when we were sitting in title with the closing, we noticed that they basically only put my name on the title, and it's because I did all the work to get the closing. I sent all the documentation or whatever. While we were there, Michelle and I realized that, and we realized that we should get the paperwork cleaned up. We asked the title company the best way to do that. They couldn't reverse all the closing procedures, and so then we had that paperwork done after the fact.
And so it was just, both of y'all's name being on there was the gift. Are you saying that it was just to reflect that that was community property owned by you guys? Okay. And the court, Judge Bailey found that to be community property last time, right?
Yes.
And the Court of Appeals didn't take issue with that.
Correct.
So I wanted to talk real quick about settlement offer as well. Can you turn to exhibit P80? Do you recognize this document?
Yes.
Is this the settlement offer that we sent to Ms. Chase?
Yes.
Just big picture, can you tell the committee what did you offer Ms. Chase on June 30th of this year?
Yeah, I mean, verbally, we offered this right away. The same, just want to move on, 55-45. And so big picture, what's offered, the settlement offer is 55-45 split with the Oregon tool performance units. We also provided the evidence of how many performance units were there. We reached back out to Oregon Tool so they could provide all that information. And then secondly, I offered a path for Ms. Chase to stay in the Cloud Crop residence by buying out my 45% for a reduced price of $75,000. This is something that the New Mexico attorneys had actually already talked about. We've brokered over email a settlement, if you will, over the Cloud Crop residence. So I thought we would package the two together, and try to get the two issues behind us.
Did Ms. Chase accept that offer?
No,
Did she even send you a counter offer?
no,
Have you had to spend money for attorney's fees since then?
yes,
And are you asking the court as part of your request today that Ms. Chase be required to pay you with reimburse with all the attorney's fees you've incurred since the settlement?
yes.
Who don't pass the witness?
Okay. Ms. Chase, you may cross-examine.
May I have him sworn in under the Bible?
He's been sworn in.
I.
You may proceed with your questions.
I want you to know that you are under oath and that you are swearing.
Object, side.
You got,
Sustained. Just ask your question, ma'am.
don't lie. Can I present this? This is an exhibit.
You can approach him and ask a question.
This is your exhibit that you testified to March 7th of 2024 property division. Do you understand that lying under oath in division of property or modification of child custody is a felony?
Did I object to compound question? Also, this is an exhibit. I haven't seen it, but it sounds like not one we have today.
Sustain. And Ms. Chase, again, I'll remind you, you have to ask him a question.
And I will.
Yeah.
Without the sidebar, you have to ask him a question.
Stand that testifying under oath in division of property or modification of child custody is a felony offense.
Objection calls for legal conclusion.
Sustain. And the questions can only be limited to property division.
Okay, and that is fine. He brought up a lot of different things. Have I seen my child in a year? So, I mean, this goes to a lot.
You can ask your question.
Do you see anything in this document that isn't true?
I'm gonna object to her asking him to testify to not an evidence.
Sustain.
School tuition, this is a monthly fee, monthly schedule. School tuition, did we pay $6,250 a month for school tuition at the Episcopal School of Dallas?
Just, I'm gonna get object to her asking.
No,
a question.
or did we pay for it the year before?
Sustain.
To document.
Sustain.
Did we pay monthly?
Ma'am, you have to ask your next question. I've already sustained that objection.
I document, I'm asking him an actual question.
About the tuition, right?
Did we pay tuition?
Right, and I'm telling you, you have to ask him another question. You cannot ask him that. I've already sustained the objection.
Pay for Christie in 2022 and 20.
We had two daughters going to ESD, and if I remember correctly, ESD is roughly $35,000 to $40,000 a year per. And so times two, that's $70,000 to $80,000. At different years, while they were growing up, in different years. We were fortunate enough to either have a bonus or some money that come in set aside in savings so that we could pay everything up front.
And so we did not pay it monthly, correct?
When you divide $80,000 by
We
12,
paid it with community property the year before.
I don't understand the question.
We did not have a monthly fee in 2023 or 2024 for school tuition. We had paid it in full in February of the year before. Correct?
Go ahead.
I offered.
Wait a minute, hold on, sir. I didn't get Mr. Page's
I
objection.
think she hadn't corrected. I was saying objection sidebar, but she hadn't corrected yet.
Okay. You may answer the question, sir.
I offered and we paid for our community property for an accountant that you chose to go through each and every one of our, all of our different finances and all different steps.
Did you?
Michelle, I'm answering the question. Michelle, when there's a difference between cash flow, net income, and how money actually flows. And so in that schedule, when I take $80,000 and divide it by 12, take $80,000 divided by 12, is how much, Michelle?
You're not asking me
It's roughly
questions, I'm
6,000.
asking you questions.
I'm not answering your question.
You
So
presented
60,
this to the court as to where our monthly fees were going, is that true?
Judge, I object that she hasn't even finished his answer to your question.
Sustained, and I guess, wait a minute, Ms. Chase, what is the relevance to this line of questioning to the property
I'm
division?
sorry.
No, I'm sorry, because you're not gonna cut me off anymore. What is the relevance of this line of questioning to the property division?
We were missing $500,000 in savings, $65,000 a month in income, part of which was community property severance for 5 months. He presented this document and presented an line item of every single penny as to where that $55,000 a month we were spending. This was a complete lie. I have documentation as to it. And I'm just trying to get him to answer. Did we spend $6,200 a month in school tuition, or had we paid it out of community property the year before the divorce was even filed?
And I asked the question again, what is the relevance to today?
And spent. This is community property that the Fifth Court of Appeals has remanded. And I'm trying to tell everybody that this is not where our money went. Where did our money go? And it is findable, but this is a lie. This is not where it went.
Okay,
It says, did we spend 200?
so you didn't present any exhibits to show otherwise? Okay, so you can ask him another question. I just want to remind you though, every question that goes outside the scope of what the Court of Appeals tasked me to do, he's going to object.
Okay, so the entire property was remanded.
Oh, you're asking him a question.
Okay. So I'm asking you, the entire property was remanded. In school tuition, were school lunches included in that school tuition?
I object to compound of this question if it got remanded or if it's a question of tuition or school lunches.
This is as to where our community property has gone.
Sustain, rephrase.
Okay. Did we pay $200 a month in school lunches?
I'm gonna, I guess, object to the point of relevance. I also don't have any, if there's a.
Sustain to relevance.
Yeah, if there's different ways claim from what she brought last time, we had no notice.
I'm sorry, I am representing myself per se, so you'll have to forgive me if I'm not phrasing questions properly. I'm not trained in litigation. This is the first time I've ever been in front of a court. So I'm trying to get at where our community property has gone. He has stated it's impossible now to evaluate our community property, and it's not.
Well, again, this is your opportunity to ask him any questions that he has. And if you believe that he's not being truthful, then you were able to present any documentation to show otherwise. I don't have that before me. So the appropriate, what you're trying to do, I think it would be better if you wait until it's your case in chief and tell me what you want to know, because the line of questioning you're trying to get out of him, you're not going to be able to overcome the objections that his attorney is making.
Okay, so can you clarify? I'm sorry. So when it's my case in chief.
You can tell me what you want me to know.
Okay, so when he's questioning me, is that what you're saying?
No, you'll go first and tell me what you want to know, and then he will cross-examine you on what you said.
Okay.
Yeah.
Thank you.
You're welcome.
Okay, so, the entire property is being redivided. Can you tell me, what happened to our children's bank accounts?
Objective vague on which accounts we're talking about.
Sustain.
So my children had 2 savings accounts. And I want to know what money was taken out of the children's savings.
The objection was sustained, so.
It was sustained. So you may ask your next question, ma'am.
Okay. Did you take me off of all credit cards against standing orders?
Object to relevance, this is not an enforcement action.
Well, it's
Sustained.
not liability for the credit.
Sustained. You may ask your next question.
All right. Please see exhibit 15. We're 15. 15, oh yeah, it's all 15. Would you like to see my notebook?
No.
Can you please read the address?
I'm home with you.
Can you please read the estimate value of the property?
$3,524,500.
Can you please read the date that this was printed on?
It's February 29th, 2024.
Correct. When was our home on Walnut Hill sold?
September, October,
When was the contract on the home signed?
2004.
It was signed in August of 2024.
Object to the sidebar.
Sustained.
When did you list the property for sale?
In the summer,
Do you have the date?
sometime in June.
How long was the property listed before it sold?
I listed the property after I left in town,
How many months before it went under contract?
a couple of months.
So do you think that it's fair that the property estimate was over 3.5 million, but yet you sold it for all cash for 2.7? And I have no information as to whether or not negotiations were made. Were negotiations made with the seller? Was there more benefit to you besides that 2.7 million?
What questions do you ask?
I'm asking you if there was more benefit to you in the sale of that property in addition to the 2.7 million cash.
That's your date question, so,
Oh, really?
yes,
You are under oath.
yeah,
Okay. You believe that the property estimate being 3.524 and selling it 2 months after it's listed for 2.7 is fair market value?
yes.
I would like to see proof of that.
Object to the sidebar.
Sustained.
Did you, in addition to your annual Oregon Tool bonus, receive a Christmas bonus?
Objection vague as to which Christmas we're talking about.
2024.
Then I'd object.
2023 Christmas bonus from Oregon Tool.
No,
Yes, you did.
Objection sidebar.
Sustained. You only can ask him
Did you
questions,
split
ma'am.
that Christmas bonus 5545.
I
don't know what a Christmas bonus is.
He's already testified there was no Christmas bonus.
Sustained.
This isn't the 1950s where we're handing out Christmas bonuses.
You got a Christmas bonus from Lennox every year, and yes, you did. I got the receipt of the Christmas bonus.
Object to the sidebar.
I
Sustained.
have information being turned over. How many times have you sued me?
Object to relevance.
No, it's where our money has gone.
Sustained. You may ask your next question.
I'm trying to figure out where our finances have gone.
And I'm trying to figure out why you're not asking the next question, ma'am. Go ahead.
How much have you spent in legal fees suing?
Objection relevance.
Sustain.
How much more did you spend in trial than I did out of our community property? And I was not allowed equalization of attorney's fees,
Objection vague.
$100,000.
Objection vague and compound.
I had.
Sustain.
Attorney's fees.
One question at a time, ma'am.
I can't even seem to get a question through. I'm trying to figure out where our community property has gone. This is a remand of the entirety of the property.
And that does not mean that you're not free from getting objected to. Sustain.
Did I receive equalization and attorney's fees?
Objection relevance.
Sustain.
Community property. How much did you spend in attorney's fees in trial?
What trial? We're on our third one and.
This is our second trial. This is the remand of property division. Our first trial on March 7th was 2024. How much did you spend in attorney's fees?
Judge, I object to that being vague, to the extent that he would know exactly what was spent on. Final
you-
presentation. Mr. Chase, can I finish my objections? To the extent you would know what is for a trial preparation versus coordination for some other event. Also, for what it's worth, we've had trial in multiple different cases like the enforcement case.
That you signed.
Sustain.
Good.
You may ask your next question.
Okay, so. Did you take all of your attorney's fees out of our savings and out of our severance?
Object to relevance.
Sustain.
Community property. That is,
There's a balance sheet that was presented earlier, and that's the balance of what the community property was.
because you took it out, you.
Okay, question.
Question, did you set up? Did you go against standing orders?
Objection relevance because we don't have enforcement set here today.
Sustain.
Standing orders clearly state you are not to set up a separate account nor take money out of community accounts. Did you do that?
Object to compound and sidebar at the beginning.
Sustain.
How many credit cards did you take me off of?
Objection vague, yes, time frame.
Okay,
Sustain.
was it 5 credit cards? Did you take me off of 2 credit cards, 3 credit cards, 4 credit cards? How many credit cards did you take me off of and then run up credit card debt and use it as your liability
Objection.
against me?
In vague, time frame and compound.
Sustain.
I want to go back to the cloud property. I was not on the deed of the cloud property, correct?
I think that everything around the Cloudcroft property was turned in at the time of that court. It's all in all the exhibits and it's everywhere, so.
When
I don't
was
know
the
what-
deed of the cloud property signed over to me?
But I guess object to vague because I think there's at least 2 deeds to that property in evidence right now. I don't know if she's referring to the sale later on where she got a deed from the divorce.
Sustain. Rephrase.
Was I legally able to put the cloud property on the market by August 1st?
Object calls for you.
Did I?
Hold on 1 second. Let me read back your question. Was I legally able to put Cloudcroft property on the market by August 1st?
2024.
Sustain. Rephrase.
Have you signed the deed over to me for the cloud property by August 1st of 2024?
It was your property to sell.
Do you understand it's a legal impossibility if one is not on a deed to put a property up for sale?
I guess I'm gonna object, when all this is a legal conclusion, but it's the whole line of questioning that if we're talking about the sale of the property that was ordered to the divorce decree that Ms. Chase herself has had overturned, it's not a relevant question for dividing a community property as of the date of divorce.
Sustain.
Did I ask you to sign an addendum that would have allowed me to have listed the Cloudcroft property on August 1st of 2024 so I could comply with court orders?
And again, fact check.
He asked him about it. He asked him about it.
She signed an addendum that would have allowed me to have listed the
But
crowd.
I'll actually withdraw my objection. If she wants to spend her time going down this route, that's fine by me.
Thank you.
Okay,
Did you sign the addendum?
Shoot a second. I think it was the day before August 1st, I got an email from the realtor Debbie Loper.
This is a yes or no question.
I'm sorry.
Did you sign the addendum?
I didn't hear if there's any objection to that, so I think he'll finish his answer.
hold on 1 second. My court reporter cannot write down what everyone is
At
saying.
the same time. You can only get one person.
So I was gonna say, if there's not an objection, I'd like Mr. Zimmer to be able to finish his answer to the question.
Okay, so was the last question, did you sign the addendum?
Yes.
Okay, Mr. Zimmer, answer that question.
Yeah, I don't know. I really, I don't know what you're talking about. So what I'm trying to do is explain from my side what I saw. And
Objection narrative. Your attorney asked you to.
Hold on. You asked, what do you want him to say? Did you sign the addendum, sir?
ultimately, I signed an addendum that allowed her to sell the club.
No, you did not.
Okay,
Yes.
so he answered that question. Go to the next question.
You did not sign the addendum. I was not able to list the property on August 1st of 2024 because the deed was not signed over to me until September. The day the deed was signed over, did I list the property?
Sustain.
Did I list the property?
Sustain. Ma'am, you have to ask a question.
Did I list the property as soon as the deed was signed over to me?
Yeah.
Are you lying under oath again? You understand you're perjuring yourself.
Objection, Ms. Carrot, we had to hold enforcement because she waited like a month and a half after getting that addendum to list the property for sale.
And we will go to that. So I wrote an addendum. I could have listed the property by August 1st, 2024. You would not sign
Okay, sustain, hold on.
addendum.
The court of appeals told me to do a job. They told me to remand the property division. The line of questioning that you're asking of him is not helping me make the decision that I need in terms of what you would want me to do. Are you wanting me to find out whether or not he's telling the truth about the addendum? That does not matter to me. What matters to me is what the Court of Appeals told me to do. And if you keep asking him the same question over and over again, all you're doing is diluting what I need to do, and you're not helping your case.
Trying to defend against what he asked his client, which
Okay,
is not the full truth.
but here's the deal though. You're going down a rabbit hole trying to play defense that's not helping you. All you're doing is running your time out. He has 21 minutes and 3 seconds left. I've taken so many notes on the questions he's asked his client specifically about the performance shares and Cloudcroft. That goes to the property division. You have 29 minutes and 17 seconds left. Only thing I know for a fact is that you believe Mr. Zimmer is not telling the truth and that he did sign the property addendum. Or had you signed the property addendum? That's all I know so far from him.
Yeah, I heard him in court. When he questions his client and misleads the factual information, I am trying to legally figure out how I can rebut the misrepresentation of exactly what has happened.
Usually when you're trying to rebut based on the questions that you're asking him, you will provide some sort of document or some sort of demonstrative aid to assist the court. You didn't provide that.
I've had 14 days.
Okay, we're past that.
Okay.
We're in the trial.
So I'm doing the best I can in 14 days, representing myself when an attorney is misrepresenting.
Are you going to ask him a question?
I'm going to try, but everything keeps getting objected and sustained. So
And that's what happens in court, ma'am.
Obviously, especially when I'm the respondent.
But just like too, Ms. Chase is a licensed attorney. It's not like she doesn't know what's going on. She went to law school. She knows what hearsay is. She knows the rules of evidence.
The court is aware.
15 years.
Okay, you may ask your question.
Nice try, Spencer. And yes, I passed through bar exam and I have an LLM, but I spent.
Miss Chase, congratulations on all of your accomplishments. I need you to ask him the question.
What happened to the 500,000 in savings?
I guess objective A is what we're talking about.
Sustain.
Our lifetime savings after a 24-year marriage, we had 500,000 that went missing and it went into a different account against standing orders.
Object to that whole sidebar.
Sustain.
Why would you have $100,000 more in attorney's fees in 6 months than I would?
I don't know, Michelle, no.
And why did you take that out of community property? So I had to take out loans to pay my attorney's fees.
Really, I don't. Yeah, to the extent that it's anything we've talked about, I'd object to attorney-client privilege.
You mentioned earlier,
Hold on 1 second. Why would you have $100,000 more in attorney's fees in 6 months than I would sustain?
You wrote in your line items, and you just mentioned it as well, that we had club fees and expenses. When did we drop our Northwood Country Club membership? Was it on or around August of 2023?
I'm just trying to think back.
Yeah,
Hold on 1 second. What's the objection? I don't have it.
Yeah, I'd like to object that he's not finished his answer to the question. I'd like to be able to answer the question before Ms. Chase has to say.
I'm sorry.
Okay, you asked him, when did you drop our Northwood Country Club membership? Mr. Zimmer answered that question.
I think it was in the fall of 2023. We were hemorrhaging.
It was August of 2023 when you filed for divorce.
Object to the sidebar.
Sustain, ma'am, when you ask him a question and he answers it, you cannot get combative. Okay, you have to ask him a question and keep asking him questions. You cannot interject your commentary.
So you've included that in your line item of expenses as well, when we actually didn't even have a country club membership.
Yeah, object that that's again asking to testify to not evidence.
So you have included that.
Wait.
So you have included that when we actually didn't have a country club. Okay, finish that question.
Did you testify under oath that we had country club expenses when you had actually canceled our country club membership 6 months before trial?
Is there any book that I should be looking at? I don't know. You're bringing up stuff from 3 years ago that isn't even in the book that we've been talking. And you question me on something that you've got a piece of paper of, and I'm not really understanding why.
Did you take our community property
I tried
and
that.
take your girlfriend to Paris on our community property?
Object to content.
Sustain.
Did you use our community property to buy your girlfriend furniture?
No, I didn't.
Did you use our community property to travel with your girlfriend?
I'm not sure because she has a job, so she pays for all her stuff and I pay for mine, but
Did you use our community property to spend over $1,800 on Coldplay tickets?
Object to, I guess,
I really don't.
the best evidence. Well, there's evidence of some $1,800 tickets. I'd like to see it.
Okay, well, you
Sustain.
want to see it? Waste of community assets on Paramore, $40,566.94.
Sorry, is this, are you looking at?
Additional, this is my exhibit from the first trial.
That I go to objection to asking
You
questions based on.
you said you wanted.
Wait, but one at a time, please. One at a time.
I would object that she is asking the client, the witness to testify to not done.
Sustain.
I could not present evidence.
Sustain. You may ask your next question.
Well, it's pretty clear that,
We're off the record.
He has stolen all of our community property and I have.
does that conclude your cross-examination?
See what else?
Mm-mm.
Did you charge up credit card debt?
Now we're back on the record.
Did you charge up credit card debt on credit cards that I had no access to and claim it as community liability?
Jack, calm down.
Okay, I'll ask them separately. Did you take me off of credit cards?
Like today, it's a time frame.
Sustain which time frame?
Did you take me off of credit cards starting in December of 2023?
Sure, as we move stuff around, sure.
Do you know that that was against standing orders?
And Jack calls for legal conclusion and relevance to their.
Standing orders.
Sustain as to relevance.
It's community
I
property.
remember responding to every discovery request that was sent to me. I remember going through 2 rounds of mediation. I remember
That's not
being
what you-
in every deposition. And that's probably why my legal fees were
That's
sized.
not what I asked.
One at a time. Let him finish.
The last thing he said was that's probably why my legal fees were as high as they were.
So I think for.
Hold on 1 second, sir. Now she needs to ask the next question.
Did you take me off of credit cards?
I'm gonna get to ask and answer because he did answer that question.
Sustain.
I didn't hear the answer. I'm sorry, forgive me.
No, don't answer that question, sir. I sustained it. You may ask the next question.
Did you rack up credit card debt on credit cards I did not have access to?
Object to relevance on, he's allowed to use credit cards that she doesn't have access to.
And she claimed it as community liability?
That's how community property works.
1 second. Did you rack up credit card debt on credit cards that I did not have access to?
I was on.
Hold on 1 second. Sir, answer that question. Did you rack up credit card debt on credit cards that she did not have access to? It's yes or no.
I don't know how you define rack up, and B, I really don't, I can't recall from 3 years ago how we were cash flowing our life. I know that we were hemorrhaging because we had a very expensive property that we couldn't afford. We were hemorrhaging because our kids were at private school. We were hemorrhaging because we were at country clubs. We were hemorrhaging because lawyers were swarming around. We were hemorrhaging because we had to go through 2 rounds of mediation. We had depositions. I got to do another deposition. We had multiple discovery requests where I had to go back 5 years to provide every single account.
Objection, Aaron.
So
Sustain.
I don't know how we.
Well, we can stop at that point. I don't know what your definition of racking up, but he definitely said a lot.
Multiple credit fees.
Well, he said a lot, so you can ask him. I don't know if you want him to continue down that line. Okay, so yeah, ask him the next question.
Did you just say that we were hemorrhaging for private school fees that we had paid the year before, Elliot?
We were spending more money. We were spending more
One
money.
at a time.
We're spending more money than we were making, and so in my opinion, we were hemorrhaging. You and I actually had a schedule where we said that our money balance would continue to go down because we deliberately said we would spend more money than we would make. Because you didn't want to go to Portland, and you wanted to stay in this house because you loved this garden. And so as that balance was down. I'm sorry, I defined hemorrhage as we're spending more money than we're making.
Did we pay ESC off in 2022, February of 2022?
I'm gonna object to ask and answer because this was. 10
That's
minutes ago.
great, so he just brought it up again.
One at a time. One at a time.
Don't perjure yourself.
Sustain, ask and answer. Ma'am, you only are allowed to ask him questions.
Okay. Did we drop the country club membership, but you just mentioned it again, as if we had a country club expense? We did not. Where did our money go, Mr. Zimmer?
I think I laid out the situation that was at hand. We had a house, well, I forget the monthly expenses, but it's probably in all these different schedules. But we had a multi-million-dollar house. We had all all the different things that were happening. I paid for an accounting for.
One at-
Hold on, you have to allow him to finish his response, then you can ask.
I'm telling you. I also paid for an accountant that you chose to sit there with you and walk you through all this, to sit through mediation with you, not once but twice. And so that they could explain how money works and how all this was happening, what was happening in our budget. So, Michelle, we were spending more money than we were making, and at some point, cash comes out.
Sustain.
That came out, I had.
Hold on, no. No. Questions only.
Did you pay for that account? Or did me and my family pay for that account?
I don't think you and your family paid for that accountant.
I know for a fact you did not pay for that account.
Just a sidebar.
Sustain.
You mentioned that this line item, I'm sure it's in the line items. So can I present this now to him since he mentioned it?
It's not in evidence.
Well, he said, I'm sure it's in the line items. This is the line item.
I wanted to.
You may ask your next question.
I'd also like to reflect that Ms. Chase, who's coming here and said she didn't have time to prepare exhibits, is sitting here with a binder just as thick as ours with a list.
I don't have this, because this is from my attorney from 3 years ago, and I don't have this electronically to provide to them.
Okay, so continue.
So I'm sorry that I had.
Hold on, ma'am. You are out of order.
So, Ms. Chase, for the record, you're confirming you were sitting there with the binder of exhibits that is nearly as thick as the binder that we came today.
This is Lisa Duffy's binder.
These are exhibits that you have brought from the original trial, correct? As you sit here today.
Yes.
Okay.
Your point being?
Here, go ahead.
Okay. So. I want to make it clear. What settlement offers has my side made? I believe Mr. Page said that you guys offered a settlement offer in June. That was a counter offer, wasn't it? Did you make it the original settlement offer, or was that a counter offer? How many settlement offers has my side made?
Can I ask for, I object to A because I think we're talking multiple lawsuits.
You lied.
Instead of together.
Sustain.
You flat out lied.
That's the last time you will address him.
So,
Excuse me.
I'm sorry.
No, I don't need an apology right now. I need you to understand what I'm saying. That is the last time you address him. That is the last time you interrupt me. You're an attorney, so you're held to the same standard as any other attorney. You know not to speak when anyone else is speaking, ma'am, even when you are representing yourself. Have some candor, okay? Go ahead. Go ahead with the question.
How many settlement has my side made?
If I don't, A is time frame and lawsuit.
Sustain.
Did my attorney make a settlement offer to your attorney, first to New Mexico, last spring?
I'm gonna try to answer and help you out. As best I can, please. Your attorney in New Mexico offered my attorney a settlement offer on the cabinet itself, and I referred to that in my testimony. And that's what I referred to in my settlement offer back to you, and in an email, we had agreed to what we would do with the cabinet. I tried to help you out by saying, I'll honor that, because I actually want you to have a place to live. In terms of the settlement offer, since the remand came down, I have received no formal settlement offer from you or your attorneys.
Lindsay Ring, are you aware that my attorney Lindsay Ring has made a settlement offer to Spencer Page?
The only thing I've seen from Lindsay Ring is an email saying that you would not acknowledge and did not want to engage with our settlement offer.
Well, then your attorney might have been,
No, ma'am.
so,
Question.
question.
I'll answer for you.
No,
before you
so
ask
are
the
you
question.
aware that your attorney made a counter offer to my attorney?
No,
Yes. Are you aware that I asked in my settlement offer for our children's bank accounts to be returned to them.
That was all communicated verbally, and I think that that's ludicrous because I don't really even understand what you're talking about.
Our children, they're listed in one of the exhibits, in one of the schedules, our children had 2 bank accounts, 2 savings accounts. Are you aware that you drained those savings accounts? Are you aware that your children came to me telling me you drained their bank accounts?
Objection calls for hearsay and also that.
Sustain. One question at a time.
Did you use our children's bank accounts for your attorney's fees?
Absolutely not. And I live with our children and we don't talk about bank accounts and those kind of things. Actually, they're doing really well.
Oh, really? Are you aware that the last exhibit I saw with our children's bank accounts, one had $15 in it and the other had 5?
Object to asking him about a document, it's not in evidence.
Sustain.
I have personal knowledge of it. Are you aware of how many times you have sued me?
Objection relevance, I think she's already asked the question.
Sustain.
It goes to our community property.
You may ask the next question. You don't have to tell me anything, ma'am. He's the witness.
Shall we?
No, sir. Hold on. Wait on the next question.
Are you aware that you were to turn over my car title in March of 2024?
I'm gonna object, I mean, this is based on the property division decree, which as of we sit here today, is not enforcing that. So it's no relevance to this.
I have a car title.
It's just, can I finish my objection?
Go ahead.
It has no relevance to this court's determination of the division of community property.
Sustain.
Are you aware of the value of my car now that I still don't own?
I would also object relevance to the value of the car right now, because we're dividing that based on value at the time of divorce.
Sustain.
I still don't own a car. Are you aware that I have now had a warning and I issued a citation yesterday because I can't get my car registered because I don't own my car?
There's three different rounds of attorneys. I've worked with Spencer to try to figure this issue out for you in Texas. I've offered you a path to get your title in Texas.
I do not live in Texas.
I know that you said
Back
that.
to interrupting his answer once again.
Ma'am, let him finish his answer.
And through your attorney in New Mexico, my attorney's in Mexico, we went back through the paperwork to try to transfer. And I signed and notarized and did all the things that were necessary. Since doing all that work, I have not heard anything from you about your car. So whether or not you can take the paperwork that's been signed over to you down to a DMV and get yourself the right documentation is not my issue at this point.
Yes, it is. You have to. Are you aware that you have?
No, ma'am. Question.
Are you aware that you have to sign and send by snail mail? You have to notarize and hand sign. New Mexico will not accept copies. And that was, are you aware that your attorney provided that information to you?
I signed and notarized everything that I've been told to sign and notarize and all,
Emailed it. That is not acceptable in New Mexico.
but the attorney.
Are you aware that this was? You were
Question.
notified of
Question.
this in May?
Question.
Are you aware that you were notified of this in May? And still have not complied? You were to turn over that car title as of court orders on March 7th of 2024.
This is a great example. This is a great example.
Hold on, Mr. Zimmer.
I object to Tom, and again, and also for the record, Ms. Chase, not only is she an attorney, but she has been instructed by this court multiple times today on how this is supposed to work and refuses to comply with the court's instructions.
I'm sorry, did I mess up again?
All
You may-
single question.
You may ask your next question. You have 8 minutes and 52 seconds left. Attorney Page, you have 21 minutes and 3 seconds
I'm
left.
done.
Okay. Attorney Page, any redirect?
Just very briefly, Judge.
Go ahead.
So Elliot, on the Walnut Hill house, you said that that house was vacant for about 2 months, as far as you recall, before it sold.
Yes,
Do you believe that the value you sold before was fair market value?
yes.
Okay, it's 2 months of that, I mean, that wasn't a fire sale, was it?
No, it was not.
That wasn't a what?
Fire sale? And when you're looking at, when she asked you about P15, which was the Zillow screenshot,
Yes,
as you understand, would you agree with me that a Zillow estimate or a estimate, as they call it, is not a professional appraisal?
Correct.
Would you also agree that any sort of estimate is exactly that, just an estimate of fair market value?
Correct. There were many issues inside the house that were aging and so on and so forth. And so you get in, you get professional realtors and you get appraisers and you get everybody involved in the sale of a house, and you can't sell it gets very difficult to sell a house if it can't appraise for, you know, what it's being sold for.
Okay, and just to make it abundantly clear, because there was a number of questions about allegations about stolen community property. Have you stolen any community property? No. Have you stolen any money from your office? No. Okay. Have you done anything, as far as you're aware, done anything to violate the standards?
No.
Okay, well, that's the.
Okay, anything further from Mr. Zimmer? Ms. Chase? Okay, all right, Mr. Zimmer, you may return to your seat. Attorney Page, you may call your next witness.
Thank you, Judge. I would call myself just briefly for attorney's fees.
Okay, you may proceed.
Judge, this is already in evidence, but just so that the court is aware, our exhibits. 79 is a summary of the attorney's fees that Mr. Zimmer has incurred since sending the settlement offer over to Ms. Chase that she rejected. We've got every single redacted invoice that shows the expenses. We've got unredacted copies for the court to the camera if the court so desires. As we sit here today, Ms. Chase has, not only has she frustrated the court's instructions even today, but she's frustrated the court's instructions throughout this process. As we put on record earlier, she's sitting here with a binder full of what looks like dozens and dozens of exhibits, and yet she told Judge Lee that she couldn't be here in the morning. She didn't have time to prepare exhibits. She told you this morning that she didn't have time to prepare exhibits, and that's absolutely not the case. Mr. Zimmer has gone above and beyond, even yesterday, with us filing the last minute response to her mandamus for something that should have been very simple. The Court of Appeals gave an instruction on performance units. We could have easily accomplished this without needing to get the court involved. We come back here, again, she refused to do that. And as you can tell by her demeanor today, she refuses to cooperate with anything going forward. So we are asking that she be required to pay his attorney's fees. 80 is that settlement offer we sent over. And then 81, P81 is my affidavit in support of our request for attorney's fees. And if I line by line on that affidavit, it would summarize everything that all of my testimony as it relates to attorney's fees and reasonableness and necessity. So Judge, we're asking for in addition to the property division, we're asking for a judgment in the amount of $23,325 for attorney's fees that Mr. Zimmer's incurred in relation to this stability man. And with that, I'll pass myself as a witness.
All right. Ms. Chase, you may ask Mr. Page or Attorney Page any questions you have about his testimony.
I again state that we're the ones that sent over the settlement offer.
Do you have any questions for him?
I mean, did my attorney or did my attorney not send over the initial settlement offer?
Not the initial settlement offer, no, the attorney did send a settlement offer that Mr. Zimmer testified about and wanted, I want to say it was $200,000 to $300,000 that you alleged that you stolen out of the estate.
No, that's not.
It's a number. Let me finish my answer. There's a number of things in there that were not supported by the evidence. The court didn't rule upon last time, stuff you didn't even ask for at trial last time. And your attorney conveyed to me, she wanted to try to get the case settled. So we sent her a settlement offer that was, frankly, in my opinion, and all of Mr. Zimmer's settlement offers that sent a number of cases have been very reasonable to you, favorable to you, and less favorable to him, trying to get this done with, and you rejected that.
I'm sorry, can I verify something to
You can clarify the question you're asking him.
I actually have a legal question.
I can't give legal advice, ma'am.
I know that settlement offers were relevant in court. I did not believe that you could bring settlement offers into court. I thought that was illegal.
Do you have a question? Sustain. You have to ask him a question.
Is it legal to bring a settlement offer into court proceedings?
This is the first I've had to make an objection, but I would object that I can't give her legal advice because I don't represent her.
Sustain.
I'm gonna object to him bringing the settlement offer.
What's your legal objection?
The legal objection is, I'm just gonna say it's hearsay.
Judge, it's for,
Response.
yeah, Judge, a couple of things. One would be that it's already in evidence. Judge Lee, Mr. Zimmer, and myself, and this court waited from 8:30 this morning till 10 o'clock this morning for Miss Chase to show up and be at the exhibit conference, which she decided not to show up to. But she did make her objection at that time. She did make the objection at the beginning of this trial when you admitted our exhibits and evidence. And on top of that, it is a settlement offer for the purposes of attorney's fees. There's a case, Lawrence v. Bowles, that allows the court to consider settlement offers for that sole purpose, and that's why we used it today. So it is.
Okay.
Overrule.
I'd like to make clarification.
You can ask your next question.
Do you recognize the email from this morning? Monday, July 20th. From last night. Trial with Judge Bailey.
I'm object to the extent this is something that's not in evidence.
Well, it's, you all mentioned it. You all.
Are you referring to 82 or 83?
I am referring to an email that was sent this morning that clearly says that trial was to begin at 9 a.m. and that there would be a conference at 8:30 a.m. This email nowhere states that trial today would start at 10 and that I would have time to.
Okay, you're here. You're here. You were here timely. You got here before 10 a.m. So you can ask him the next question because that's not relevant. You may ask him the next question.
The conference this morning that I was given more time to prepare for. Did the judge say that trial wouldn't start until 10 a.m.?
So, yeah, so P82 and P83, which were both in evidence.
And I don't propose.
If I can finish my testimony. P82 and 83 were both in evidence. Judge Lee responded because he refused to have a conference yesterday by Zoom. So if you refuse to have one.
That's very fine.
I think my testimony. You asked a question and I'd like to answer your question. She offered you the ability to do it by Zoom during the day yesterday. She offered you to do it by Zoom after hours. She was willing to stay after hours and give you the time so you could do a conference by Zoom last night. Or she was willing to have an in-person conference this morning at 8:30. She gave multiple offers to you. Frankly, I think Judge Lee did more than she's required to give you the opportunity to be present to participate. And then she confirmed there's emails in, it's either 82 or 83, where she says that we can do the conference today, 8:30, and she can talk to Judge Bailey about this trial starting at 10 today. And you decided that you didn't want to show up at 8:30. Whether trial here today starts at 9 o'clock or 10 o'clock makes no difference because we waited from 8:30 to 10 at the conference to see if you'd show up. And then we're here today, just like Judge Bailey said, you were here, you were participating in this case, and we haven't defaulted you for being late.
May I please, do I have a chance to speak now?
You have another, you want to ask him another question?
I'd like to call myself as a witness.
Okay, so he's still the witness right now.
I have no more questions.
I'll pass myself as a witness.
Okay.
And I was going to ask her next, but if she wants to, I'm fine taking her out of order. If she wants to do her direct with the last 8 minutes or 6 or however she's got.
Oh, no. Yeah. Which do you prefer? Do you prefer to call yourself as a witness
Sure.
first? Okay. And you're resting, just so the record is clear.
I'm not, I would still like to use my time to cross-examine her to get it closed.
Okay, okay.
And I guess if I need to recall my plan. If the court would prefer, I can do it. I can cross her first and then she can redirect herself. Whatever you prefer, Judge.
No, she wants to speak, so
That's fine.
yes, ma'am.
May I? This notes. Or is that not allowed? I'm not sure how that works.
I'd object to that one. It's got notes on.
Yeah, you can take a blank sheet of paper.
Okay.
I need a pad, but I can give you the cover sheets.
Okay, would you like to start by crossing me, Spencer, or?
Well, you're
And then I'll cross.
Yeah.
So
so you just start speaking about all the extra that at the end of each question when you were speaking, you can speak about that.
If I can remember. Thank you, though. Okay, so first I want to start out, I have not seen any email stating that trial was gonna start at 10. I was here at 9 o'clock. I sat outside with my mother. We asked some people what was going on and they said that trial wasn't starting.
Objection to hearsay.
Sustain,
Well, I was told trial wasn't starting until.
Objection to hearsay.
sustain.
No email. I drove 9 hours yesterday. I've been sick. I have filed motions. It was set on Wednesday. Judge Lee said that we were going to set a conference, for Thursday afternoon. I requested a time, Zoom information verification on the conference.
Objected, relevance, like whether conference happened Thursday or not.
Sustain.
We have been talking about a conference this morning. I provided myself for a conference on Thursday that never happened.
Ma'am, we're beyond that. Do you want me to hear what you have to say about your property or no?
I'm sorry, he's been able to get all the information about the conference yesterday and today into evidence. Why can't I get the conference that I've made myself available to attend, spent 24
Thank
hours
you,
making
counsel.
myself available to attend, it never occurred. I don't understand. I can't seem to get anything on record.
You may,
I have not
you may
been-
proceed.
Okay,
You may not proceed with talking about whether you appeared at a conference or not. That does not matter. We're here at trial. We're here at trial.
yes, and I'm trying to explain why I didn't have time. So
You know what? If you choose to waste your time like that, we can go ahead. Keep talking about the exhibit conference. Go ahead.
I've made myself available at every avenue that I possibly can. I had to travel 9 hours yesterday. Mr. Page expected me to pull over somewhere in East New Mexico, West Texas, where I've got no reception, and make my car available as a workspace for an evidentiary conference. I'm sorry, to me that seems not only unfeasible, but unreasonable. I got in last night to Arlington, Texas. I did the best that I could, pulling notebooks, pulling whatever I could to try to create some sort of an argument today. The notice of the hearing came in 2 weeks ago. This is a multi-million-dollar estate.
To the relevance, and also I have no notice that there was a motion for continuance on file today. I believe the court's already ruled on that, so I'd object to her going into evidence.
Sustain.
You have no notice of a motion for continuance?
I have absolutely zero notice that there's a motion for continuance set for trial today.
Oh, no, I'm not saying that.
Okay, so then I'd object to relevance because it's not due to anything that's set before.
Sustain.
I'm saying I've worked the best that I can.
Okay, are you speaking now or are you talking to him?
I'm speaking now. So
Okay, go ahead.
I can, with the 2-week notice that I've had, to try to prepare for a multi-million-dollar remand of a complete property division. I don't know what else I can do. I just know what I'm missing, and I have once again had no time for a forensic audit, which I had requested before the original trial, which was expedited as well. So once again, I'm in a situation where I have no idea where 24 years worth of property has gone. I can only say that I know for a fact we did not have a country club membership that Mr. Zimmer referenced again today. We did not pay $200 a month or a month in lunches for our children. That was paid in tuition, which was paid the year before. As Mr. Zimmer stated, we paid tuition the year before the previous, the school year, the upcoming school year. I'm asking, he said that there's no way we can recreate the community estate, and I am saying that there is.
Based on making an objection,
Go ahead.
I would object that mischaracterized Mr. Zimmer's test.
Sustain.
I believe it was said that it would be near impossible to create a community estate. And I am saying that I believe it is not. I just had requested more time to be able to do it, as I had in the original trial. If you look at their spreadsheet, a lot of their spreadsheet has TBD, to be determined. That means even they at this point don't know how much things are worth. And all I'm requesting is a little bit more time to do due diligence to try to figure
I
out.
object to that. It's not a request set for hearing today. I certainly don't have notice that that would be set today, so object to that.
Sustain. You have 48 seconds left.
I have nothing more to say.
Okay, Attorney Page.
Thank you, Judge. So you said that you did not have, you said you had 2 weeks notice today, correct?
That's correct.
You agreed that the appellate opinion came down in March of this year, correct?
The mandate came in July 15th.
It was that when the mandate came down and said that we were remanded, was that a surprise? Was the first time you heard that the case was being remanded?
It was the first time that I knew that it was going back to trial.
Okay, so when the appellate opinion that came out in March said it's coming back to trial, you thought the Court of Appeals was lying to you?
No. I just know I couldn't get discovery at that time. And my understanding is I can't get discovery until the mandate
Objection,
comes in and sends it back to trial.
Sustain.
Objection on the floor. You also, you're talking about property, you've made a lot of allegations about property over a 24-year marriage. You agree that you had before the remand, we had an entire divorce case where you did discovery, correct?
I was not able to have a forensic audit done because of the expedited trial.
Objection non-responsive.
Sustain.
You did discovery in the divorce, correct?
Minimal,
And when you did written discovery, you sent a request for documents, right?
yes.
And Mr. Zimmerman provided some documents, correct?
Some, not all.
Objection non-responsive after some.
Sustain.
And then you filed at least one motion to compel, correct?
Yes,
And we had here on a motion to compel and agreed to produce additional documents, is that correct?
and you did not.
Okay, objection non-responsive.
Sustain.
Do you agree, we had a hearing on a motion to compel, correct?
Yes,
And you asked the court initially to continue trial during divorce, right? It was initially set for February of 2024.
yes.
And then the court granted your continuance and reset it to March of 2024, correct?
It was about 7 days. We got a 5 to 7 day continuance.
Okay, you understand that when you went forward to trial, March 7th of 2024, you did not ask for a continuance that day, did you?
We asked for we fought for a continuance.
You did not you did not have any motion of continuance set for trial on March 7th, did you?
Yeah, we were not granted another continuance.
Judge, I asked the court stage just notice the court's file.
The court takes judicial notice of all contents of the court's file.
And what do you think you don't know what the value of the performance units is right now, right?
No.
You don't know what's, slow down, Mr. Page, and you don't know what the value of what is?
The value of the performance is right now. You also, going through the assets awarded to you, you got several $100,000 from the sale of the Dallas zone, right?
My attorney said,
So you're telling this court you didn't get any money out of the sale of the Dallas house.
I can provide the documentation. I got very little because I had to pay attorney's fees out of my settlement.
Not what I'm asking you.
Huh, well, okay. Then rephrase your question.
Okay, well, my question was phrased correctly. You got several $100,000 out of the sale of the Dallas house,
I
correct?
did not.
You were supposed to get, before any net was taken out, you're supposed to get in excess of $450,000, right?
I'm not sure because I didn't see it.
So you're telling the court that you didn't, but you also have no idea how much you got.
There was a lis pendants on my home, so I did not see the full amount of what I received.
I'll ask you another way. You don't have any of the proceeds left anymore, right?
No,
You spent them all.
on attorney's fees, we said and sued 8 times.
Well, first off, let's talk with the attorney's fees. So there's an enforcement file because you didn't sell New Mexico residence, right?
The New Mexico resident.
Objection non-responsive.
Sustain.
Ms. Chase, I'm asking you very simple questions. There was an enforcement file because you didn't sell New Mexico residence, correct?
No,
Okay, so you're telling this court and this was myself that there was not an enforcement before this court in 2025 because you didn't sell the New Mexico residence.
It was up for sale.
Objection non-responsive.
Sustained.
I'm sorry, I don't know what you're saying. I have no idea what you're saying because I followed the letter of the law to the nth degree.
That's very clear from your activities today, Ms. Chase. You agree with me that the house is still not sold 2.5 years later,
That is
and
correct.
you're still living in the house today, correct?
I am, and it's still for sale.
Okay, and you've not got a buyer in 2.5 years.
We've had a lot of people looking.
You agree with me that you benefit from staying in the house, right?
Yeah,
Okay, and so you don't believe motivation wouldn't be there for you to sell a house. You're better off if it's not sold, right?
no, that's not the case because do I want to live in
Objection.
Chicago, Property, New Mexico?
Objection on to that or not.
Sustained.
And in fact, one of the issues you appealed from this court's ruling was the court's order that the house be sold, right?
Yes,
Because you want to stay living there.
because I want to get him out from under that property.
So you just don't want him to have his share of that property.
I want to sell the Firecroft home for 16% less than tax roll value, similar to what he sold our Dallas home for.
Okay, but you haven't even tried to do that, right? It's not legal,
Yes,
correct?
that has been in our settlement office.
You testified to this court that it's listed today, right?
Yes.
Is it listed 16% below tax roll value?
No, it's listed for
Objection
just,
responsive after no.
Sustained.
You agreed there's an agreement to split the estate 55-45, right?
yes,
Okay. And when you say that there was a lot of money that was mishandled in the estate, we had a trial March 7, 2024, right?
yes,
Okay. And you presented some evidence of some waste claims that you had at the time, right?
that is correct.
Okay. The court didn't grant any waste claims, right?
That's correct.
Okay. And you didn't appeal that part of the ruling at all, did you?
We objected.
Objection unresponsive.
Sustained.
You filed a notice of appeal with the 5th District Court of Appeals, correct?
That's correct.
And waste claims were no part of that.
Equalization of attorney's fees and waste claims we objected to, so that is part of the property remand.
Sustained.
Not my question, Ms. Chase. And again, you're an attorney, right?
I must not understand what you're asking.
Okay, I just asked you, you're an attorney, right?
Yes,
Okay. And so you've gone through law school, right?
yes,
Your years work today, correct?
Your what?
Years work today,
Your ears work to me.
my
correct?
ears work today.
Mhm.
Yes,
And so you've heard Judge Bailey give you instructions throughout this trial, correct?
yes,
And you also would agree that you've willfully disregarded those at almost every juncture today.
no, not intentionally.
Okay, so you would agree that you have disregarded throughout the entirety of today's.
No, I've explained that this is the first time I've ever represented myself in litigation or been in litigation, and so I'm sorry if my etiquette is lacking.
Okay, today is the first time you've been in litigation, Ms. Chase?
Yes, I mean, the first time I've ever represented myself or anybody in litigation.
Okay, so you've been in front of this court on, this is now at least your third occasion in front of Judge Bailey.
This is the second time I've been in person in a courtroom.
Okay, and the third time you've been in front of Judge Bailey alone, right? Actually, maybe the fourth time as well.
I'm not sure.
Okay, and you've been in front of Judge Lee a number of times over the last
That's
3 years. Okay, and evidentiary hearings, right?
I don't think so.
Okay, so you don't agree that you were part of a temporary orders hearing at some time?
Yes, yes,
In fact, you've
but
been
I
part
didn't
of,
know if that was an evidentiary hearing.
there's evidence in it, right?
Yeah,
Okay, and in fact, you've been part of multiple temporary orders hearings.
Slow down, Mr. Page, and in fact, what?
You've been a part of multiple temporary orders hearings.
I've been a part of one temporary orders hearing.
So you had a divorce with a temporary orders hearing.
Yes, yes,
And then in the modification, we had a temporary orders hearing.
yes. I'm sorry, objection relevance.
Judge, I'm just trying to establish that she knows exactly what's going on. She's been complaining left and right, not only to you, Judge Bailey, but to the Court of Appeals, and she's got no idea that she's a single mother who doesn't know how to do any of this stuff, and it's absolutely not true. And I think it is relevant to the fact that she's disregarded your instructions today. I presume she's gonna make arguments to the Court of Appeals in the future that she doesn't know what she's doing again. I think it's important to record show that she is an intelligent woman and she knows exactly what's going on. And she's had a lot of experience in litigation, much more than most people have going through the divorce process.
I'm sustaining her objection. Were you trying to make an offer of proof?
I will make an offer of proof to the extent the question's already in the records. Well, present those as an offer of proof.
Okay, thank you.
Thank you, Judge.
You're welcome.
So you testified you've been available at every opportunity in this case?
No, I haven't. I had leadership Cloudcroft on Friday. I made myself available Thursday afternoon and I've tried to make myself available as often as possible. And I've tried to work on everything as diligently as I can. But unfortunately, I did have to drive 9 hours yesterday. And most of that time I am out of range. There's no, even in Abilene, like you're still spotty after Abilene, but no, you typically do not have great cell phone range and there was no way I could make myself available. And then unfortunately this morning, I really honestly.
At this point.
Sustain.
So Ms. Chase, and I'll represent you, but I've not only been myself to Cloudcroft, a lot around West Texas there. So it's your testimony under oath right now that the entirety of the way it leads to Abilene, you have no cell service?
It's very sketchy. Yes, my attorney tried to call me yesterday and I lost her. So yeah,
Everyone in Midland, Odessa just doesn't call people on.
that's not the way you go.
Okay, so everyone in any town along the way does need cell service.
It is very limited. And that's legit. You even have to download podcasts before you go.
And what time did you get in last night?
I got in yesterday around 4 o'clock.
And so you agreed Judge Lee offered to have a Zoom conference after hours with you.
I didn't have time to prepare. I'm sorry. As you can see, I don't have exhibits. I honestly did not have time to go through 85
Ms.
of
Chase,
your exhibits.
are these exhibits that I'm looking
I
at?
don't have those electronically. That was literally something I pulled out before leaving from my bookshelf in my laundry area that I have not looked at in years and tried to go through it last night to figure stuff out. I'm
Objected error at this point, Judge.
Sustain.
And you got our exhibits on Thursday morning of last week, right?
I did, and
Objection or response to that, right? Then.
Sustain.
And you're not employed right now, right?
I'm representing a client, but no, not really.
Okay, and you've not really been employed for at least 3 years at this point, right?
2.5 probably. I ran a nonprofit for 15 years.
Okay,
So-
and you agree that's not full-time employment, right?
No,
Okay, so, you'd also agree my client's an executive company, right?
oh yes,
And we had time to prepare exhibits, right?
he has a full legal team.
Okay, and you're a licensed attorney without employment, correct?
I am not a family law attorney. Thank God.
There's no best witness to this one.
Okay.
Okay, so.
You have 45 seconds.
Okay, wonderful. Well, I apologize again for not knowing the proper etiquette. I honestly have tried. I wish I knew objections, and next time I am in court, if I am again, I will first and foremost memorize objections. And I do want to clarify one thing. I have never tried to go against this court. I 100% tried to get Mr. Zimmer to sign an addendum. The Cloudcroft resident, I was not on the deed, and it was an illegal impossibility for me to get that home on the market. The realtors would not sign the agreement because I was not on the deed. The minute I was put on the deed, he would not sign the addendum. Yeah, the minute I was put on the deed, on that property up for sale.
Okay, ma'am, you just ran out of time. Okay. Did you have any other questions for Ms. Chase?
Can I get a time check real quick, Miss?
You have 5 minutes and 1 second left.
Okay, I will ask a few questions.
Okay.
Ms. Chase, is there any sum of financial funds that you were awarded in the divorce that you have as specific today?
Yes. I want to say about $45,000.
From which account was that awarded to you from?
That's just that's where I put the money that I have.
Okay, and that was, you agree with me that was substantially less? Like, I don't put you on an exact percentage, but definitely less than half of what she got out of the divorce, right?
Yeah.
Okay, so if Judge Bailey were to divide things differently today as far as financial accounts, you wouldn't even have the money to pay to Mr. Zimmer to offset things like that, right?
I would take out one,
Okay.
so, yeah,
Even with no income, you'd be able to take out a loan for whatever judgment the court would put in place.
yes.
Alright.
I mean, yeah, so if I have to buy my home, then I'll take out a loan to do it.
Okay, and you agree that 45,000, that's enough to pay for the attorney's fees that we're asking today, correct?
I'm sorry, I won the remand. I won the appeal.
Objection, not response.
Sustain.
Lovely.
You agree that that's enough money to pay the attorney's fees we're asking today, correct?
No, I don't. I've got a $25,000 debt from attorney's fees from your lawsuit for me.
Okay, so, not my question. You said $45,000?
It was a $25,000 debt that I've got to pay.
Okay, well, you haven't paid yet, right?
I'm about to.
Okay, well.
Credit card debt.
So you don't owe an attorney. Correct?
I'm sorry.
You don't owe an attorney any of that money, correct?
It's from, I actually do owe an attorney $20,000, so yes.
Okay, so, because I'm asking you a number of questions and you've given me now like 3 different answers.
Well,
Do you,
what is this? What's the relevance of this, Spencer?
we are dividing up your estate. I don't even,
Okay,
Objection,
this is
Brett.
my current estate. Let's talk about Mr. Zimmer's finances.
I didn't
right
get,
now.
I didn't, excuse me, Ms. Chase, I didn't get your objection.
my objection to her asking stands.
What's the legal objection?
Well, I guess it's legally improper that it's not responsible. She's not
Sustain.
responsible. And I guess I'll pass to the judge. I'll save the rest of my time for closing.
Okay, Ms. Chase, you may return to your seat. You're out of time. Attorney Page, you can go ahead and close.
So Judge, I think you've obviously seen a lot today. We're here on one question, which is the property division as of the date of divorce, which is where we've got to value all the property. I think obviously, Judge, you've got a lot of discretion, as you know, to divide the property in any manner that we see fit. Just from my client's own request, we ask that we don't change the property division up too much. I think you've seen just by the way Ms. Chase has acted today, that if we try to like reverse engineer the property division too much at this point, it's going to be an absolute disaster. And we're going to have to get attorneys involved, maybe across state lines to get that stuff resolved. My client and Ms. Chase agreed to a 55-45 split. Technically, the division is a little more in Ms. Chase's favor. My client's not objecting to that. He just wants to be done. He's tired of going through litigation with Ms. Chase. He's tired of spending attorney's fees on this. And I understand why that's the case. So we're asking, and I don't think she can complain about getting more than what she bargained for either. So in an effort to minimize costs for both of them, to do what the Court of Appeals has brought us back down to do, and to prevent any sort of, I'm sure she's going to try to appeal in the future to prevent any sort of appeal, we're asking to just keep that property division we have attached to our Exhibit 1. And as part of that, not change up the Cloudcroft sale or the split, but 100% give Mr. Zimmer the ability to make that sale, to make the decisions, get Ms. Chase out of that house, because it is ridiculous that we're 2.5 years later and Ms. Chase is getting up here with a straight face and trying to say that she's done everything possible to get this thing sold. I get that rural New Mexico houses aren't going to sell as fast as houses in Dallas. They also going to take 2.5 years. They take that when you have a property listed way above fair market value. We actually had a hearing judge in front of you in 2025 recall where we had an ex-witness who's a realtor in the area.
Slow down.
We had an expert witness who is a realtor in the area, and she testified that she literally would not bring her clients by the property. She was aware of the property. She wouldn't bring them by because it was so above fair market value. She couldn't recommend that to anyone.
Objection, hearsay.
The judge, this is closing, so it's not for evidence or value. We're asking you, the performance units we split 55-45. And that's really the crux of what we're asking in the forced attorney's fees, Judge. I think you've seen what we've been dealing with this 20 years.
Thank you, counsel. You're out of time.
Thank you.
Okay, so as far as the exhibits that I have looked over thus far, I'm only up to like, and I mean, I know you all referenced them, but in terms of like giving it a deep dive, I'm only up to like 60. So the court needs some time to review 61 through 83 and to review some things that I took notes on for the transcript. And I'll have you all a ruling. I should be able to get your ruling out by Thursday.
Perfect.
Yeah.
Thank you, Judge.
Thank you.
Us briefing or anything like that, obviously, feel free to reach out to us. We're glad to provide whatever what needs.
Yes, thank you.
Any questions that you need,
We're off the record.
anything, put me on, please, focus that.
Yes, ma'am. Thank you all.
Okay, so mom comes completely unprepared, which I don't understand. She graduated from law school, passed the bar exam. She knows how to act in court, and she gives this kind of a performance? That just baffles me. She comes completely unprepared. She doesn't show up to the exhibit conference. All she had to do was come in a half an hour before 9 o'clock. She said, I was here at 9 o'clock. All you had to do is come 30 minutes earlier. That's all. Unless she didn't have exhibits prepared. So she was just going to let that part go and pray the judge was going to award her the continuance. She was snarky. She was like at the very beginning, before the judge even went on the record, she was demanding. And she just did not give the performance someone would expect from an attorney. She can't even go back and say, well, I was pro se, so what could I do? She can't fall back on that because she is an attorney. She may not be working as an attorney now, but watch some of the cases. My only experience with court activity is jury duty. That's all I have. That's all my experience is. But I have watched cases over and over and over. I could at least do better than this. And you would think that she would have watched some of the cases, watched some family law, watched some just plain old criminal cases. She didn't do any of that. She didn't prepare at all. I guess she was just hoping that she would get a continuance and be able to knock it down another 6 months or something. I don't get it. I don't get coming to court completely unprepared the way she did. I have no idea how the judge is going to rule because I have no idea what she was asking of the court. So I really don't know. I just thought you guys would like to see this because it was really a dumpster fire, in my opinion. Anyway, please hit the like button, hype this video. Thank you guys so very much for watching, and I will see you all next time.